questions on him? Okay, very good.
I'd like to recall this code enforcement.
Bring him up.
Recall Officer Heatherton to the stand.
Come up.
Officer Heatherton, there has been questions regarding a letter dated March 28th, which you note in the letter of May 2nd and perhaps subsequently. Is it accurate that there's a letter to that effect?
No, that was in the century.
Can you please explain?
It should have read in the conversation of the 28th.
So for the record, go ahead.
There wouldn't have been need to write a letter when we were speaking face to face.
Thank you.
Any questions of him?
Excuse me, can you repeat what was said when you were speaking face to face?
That was when you got the permit.
Right, what
Remember?
was said then?
Well, I wouldn't have written you a letter when we were
That's what I
talking to
thought.
each other, right? So you're right, that's,
So, but when we were talking, I asked you for information on
right.
the rules and regulations, and I was told that there was nothing you could give me that would tell me.
No, we do not have a
What I'm
flyer
saying
for
is,
a
you're telling me
demolition.
that on the 28th I was informed of something, but you're telling me that you had nothing to give me. I mean, you gave me nothing.
No,
As far as
you
rules and
were
regulations, what I had to do,
informed.
all I had to do it.
Linda,
Okay,
you
let's
were.
stop.
Could I interject? I have a question, and from what I just heard in the testimony, that the code enforcement officer said that there was no letter from March 28th. It was basically the oral conversation that took place
That's how I
between
understood.
the property. If that being the case, then I think the letter of May 2nd, and I can understand where the confusion comes in. This is the letter of May 2nd signed by Galen Norwood that states in the second paragraph, says you were advised in our prior letter dated March 28th. So that should have been our prior conversation.
Yes, sir.
Okay, so that may be an inaccuracy in terms of the letter that was sent on May 2nd. And I think the cause for the confusion is probably that point there, because sitting here as one board member, it says a letter, and when somebody says a letter looks like this. It's not a conversation, it's a codification of whatever was communicated. And maybe the reason why there's a lack of a document like that is because of that. And I think that needs to be pointed out in terms of maybe the reason why some of us are confused.
Yes.
And that corresponds with the chronological order
Right.
on the front page.
The chronology does not match the narrative that's embodied in some of the letters, so.
Okay. She has a question, Ms. Spencer.
I have a question. Last October, I took out a demo permit to tear down a house. I didn't have anybody explain to me health and safety issues. I just paid my $81 and took the permit out. I tore the house down 7 months later, and I never had any notice from code enforcement about health and safety. But my point is that when I took out the permit, is that the standard procedure, is just to take out the permit and not inform the person of health and safety issues?
I honestly couldn't attest to that. I'm not a building inspector.
Your code enforcement?
Right.
Okay.
And this, as I said, was an open code case.
Okay.
So that's why my involvement there.
Okay. No, I understand. Thank you.
You have a question, sir?
Yes,
Thank you.
your code enforcement, so maybe you can answer this question. It was said in the code that I violated the code, two different codes, both the commercial and the residential zoning, that when I was carving or doing what I did there, and that I could no longer do it based on, even if the buildings were not red tagged, I would not be allowed to do that. Why? I've been doing it for 7.5 years prior to that, and then all of a sudden, because there was a fire, I can't do it anymore. Why?
Point of clarification, are we talking about this abatement process, or are we talking about the previous?
It's in the letters.
Neither.
Read the letters it's in. Please explain. How is that not on the residential side, you said it's not a home occupation. Wow. Who made that determination? And then on the commercial side, I'm not allowed to do it there because I'm not allowed to store, process, outdoor sales, or carve. Where does it say in a zoning or a code law that I can't carve? That's what you put in the letter, and I was threatened with 90 days in jail if I was caught doing so.
No,
It says it in the letter.
Let's,
Is that letter part of the packet?
Yes, it is.
Yes, it is. So please explain.
90 days.
That's what it says in the letter. Violating the
Yeah, show
code,
me
90 days.
that.
can you point to which page, just so for all of us, please?
One second, please.
And
Can you
a
staple that
point
to the
of
outside side?
clarification, what you're doing is nuisance, no matter what you label it.
You feel that it's a nuisance?
Absolutely, and
Hey,
somewhat
have
of
you
a
ever talked to
fire
some of these
hazard.
Have you ever talked to some of the other
Page
business owners in the
32.
in the area? Because of me, they actually get more business?
Well,
Or that there's actually people that come into Westwood
So-
simply to be,
so-
for me?
So, let's stop for now. I think the point's well made.
Page 32.
That's the letter.
Is that it, 32? Thank you. I think it's,
It references the county.
okay. So are there any other questions of this witness? Seeing no hands raised,
Is that all the evidence you want to present, Mr. Department Head?
Yes.
Thank you. Mr. Chairman, I think that's the evidence.
unless the board wants to hear from some other source.
Yeah, I have a question. I just want to have a sec to review this letter. I have a question of the property owner.
Sure, absolutely.
I would just like to know, you obviously want the opportunity to do this yourself. And you stated it could be done in like 2 days. Do you have the financial,
Yes.
means to do it
No,
yourself?
not really, I know part of it, but yes,
So you could get it done,
yes.
like, okay. And you also said you want to get an inspection, but you also, there's the inspection, for whatever reason, you want to get it done, but it's not going to be for insurance, or it's just going to be for your own peace of mind.
No, actually, the attorney will determine that once he has the inspection back.
So you want an inspection, and you want to tear it down, you say it'll take you 2 days, and you have the money to do that. Okay, that's right. Thanks. So, if you're going on the same, you've had a few variations.
No,
of
not too bad.
the
We've,
flag by-
generally, we've
Yeah,
stuck to it.
we,
So the question is there any other evidence before you close the public hearing that you'd like to hear? Or any?
Right, Iona McCain?
Thank you. Iona McCain. I'd like to know who is writing the letters if the building code individual says some of these things are not true, and there's a confusion in which Supervisor Chapman spoke about. So if he isn't writing the letters, maybe somebody else is misunderstanding what has happened here.
The signatories to the letters are all on the documents themselves.
But who is
Here that there was a
composing the letter?
Signature block on the letter is Mr. Anderson. Mr. Norwood signed it on behalf of Mr. Anderson, making reference apparently to this, it to me is very questionable.
Yeah, I think so.
I think that the parties in the county offices need to be talking more clearly to each other. I have a question before we close the public hearing is, I had started out to ask for a copy of the March 28th letter, which we learned doesn't exist, and the compensation is being referenced in the letter of May 2nd. But also the CAL FIRE report on the cause of the fire or their follow-up on the day of, and that was alluded to by Mr. Ewing. And that's not, a copy of that's not part of this packet, and I think it would be helpful to have that as part of the record. So is it possible to get a copy of it? I mean, obviously, the property owner knew enough to get a copy of it, but I was kind of curious as to why we don't have a copy of it in our file as part of the record that we have.
And not to speak for Mr. Anderson, but my initial reaction is regardless of the cause, certainly the condition of the property is now viewed generally as dangerous, but I think it's available.
I mean, I know it's available, it has to be available, but, you know, if the part of the delay that we're seeing between March and now to take the appropriate action to abate the property is because they want to have this inspection done, and there's a report on file that alludes to what the initial fire inspection done by the appropriate fire folks, I think that would be a central part of debunking the need for an additional inspection report being done possibly, which would take away the rationale for the delay. And so,
Let me simply ask then, Ms. Hanson, do you have a copy of that report? The arson investigation report or whatever it is?
I have,
It's in the envelope.
And if you do, might we have it
yeah,
for the record?
yeah, I appreciate.
Please.
my copy, if I don't
Yeah.
have it.
We're happy to provide or take a copy of what you have.
Okay, that's fine. This is the Westwood Fire Department report, it's the only report there is, I talked to him.
And on the premise that I won't deprive you of this permanently, I promise. And so with that assurance,
Yeah.
would you like to have this?
I'd like to see that, but I'd also like to see
I'll give it to
the
the
CAL FIRE report that Mr. Ewing alluded
I
to.
think that the when I talked to Forrest, he said that the reports from the other fire departments would be in this report, that's the,
CAL FIRE does not always prepare a report that, at least that's my experience, I don't know if one was done on this occasion. It sounds like there wasn't, but I'm not
Mr. Ewing
sure.
indicated there was, and what I'm just saying is I think the file, I would feel, yeah, well, maybe Mr. Ewing could look at this and tell me if this addresses the issue.
At the time of the incident, the discussion between the fire chief or the department's investigator and the CAL FIRE investigator, they determine who's going to be the lead on this and who's going to take the documentation side.
Well, it says here, cause of incident, electrical fire, structural integrity of building was not safe to conduct further investigation. This was the March 24th Westwood Fire Department report. I think that's the significant part, but if CAL FIRE did additionally pass this back, I don't want to be responsible for it.
I'm not either.
I'll let Mr. Burns get a copy made for the file and then return that to the owner. But, I mean, I think it would be pertinent to know what CAL FIRE has as a document that either sustains what the Westwood Fire Department has in that document, but the fact that those documents aren't in the file, I think in the future it would be helpful for these kind of discussions that we have that kind of information, you know, available and in the record.
But there's no question that there was a fire.
Yeah,
That had nothing to do with the debate.
well, I realize that, except in this particular case it does, because it's either the lack of or the lack of appreciation for the cause that's indicated there in terms of having, I mean, it was alleged at the podium that if you were to demolish something and it's evidence and, you know, you're basically destroying evidence as being the argument, I think it behooves us to find out what the evidence is, or if there's reports on file that pertain to the evidence, which either sustains the argument of the property owner or debunks it, one of the two. But, you know, I think that this, the fact everything's in limbo is because of the fact that we don't have that and are utilizing that information.
Well, I agree with you to an extent, Jim, but also, I mean, even though the property owner isn't able to be here but one day a week,
Yeah.
there is still the use of the telephone, there's still the use of email and letters and a lot of this stuff that are being done.
Well, my point isn't so much the property owner should have that, because I think the property owner demonstrates she does. My concern is the county staff doesn't have it, and that we don't have that as part of the county staff deliberation. So I think it would really help the record if we had that information, because if we did, and there's cause that's demonstrated, and it's coming from the reputable agencies that are responsible, okay, then that, in my mind, lays against the argument of the property owner who says, well, I can't do this that you want me to do because we don't know. Well, there's information that supposedly indicates that we do know. And the lack of that information on the file is a major concern.
Supervisor.
Yeah, and I think why it wasn't in our packet was because the reason that you need it today wasn't brought up until the big discussion. And again, the abatement has nothing to do with how the fire was caused. Now,
Well, I'm not worried about,
correct me if I'm wrong. Earlier in the conversation, Mrs. Hanson said they wanted to do an inspection. And they were not allowed in the building to do the inspection, and it has not been cleaned up because they haven't did the inspection. And then, when Mr. Ewing was giving his report, he said the fire department and CDF did an inspection. And somebody asked for a copy of that, and Mr. Ewing said, I don't have it. Then Mrs. Hanson said, well, I got a copy here. So if you had a copy of the inspection, why do you have to do an inspection? I mean, there's a lot of contradiction going on here.
I have a copy of the fire report, and if you look at the fire report, it says an electrical fire. It does not say the cause. How can there be
Electrical fire was the cause.
Right, right, on a building that has no electricity. I have a wall right here, and it just starts burning from electricity. That's my problem. I have pictures here that show why we have to have an
well,
inspection.
if I can go back to, I agree, I appreciate what you're saying.
Let's don't talk about things that aren't pertinent to the abatement.
It is pertinent. My concern is the fact, I don't expect it necessarily to be in the packet that I have here, but since that's an issue that's been raised, I think that particular part of the information should have been part of the file that the county has and the staff has. They should be able to produce
But
it.
my decision, whether I in support or not, has nothing to do with how the fire started. It has to do with, we got a building, it's unsafe. If people want to clean it up, it's a safety hazard, we need to do something.
I'm with you there, and I would say that the testimony of Mr. Ewing is more than enough to satisfy me that that
Very
information
good.
is there. I would like to see that followed up so that, you know, if there's any ongoing litigation on this here, that information be made an inherent part of the county's records, because I think you need to have that if you're going to back up testimony.
Okay, we're gonna hear from the property owner, and then we need to close the public
Thank you.
hearing. and bring it back.
Just so you know, when you read, I don't know who read it, the first part of Forrest's report about it being an electric fire and they were told that it was unsafe for them to go into the building for the inspection, that's where I read it. And I do have pictures to show why there needs to be an inspection on it. That if it's torn down, it can't be done.
Okay, thank you.
If you'd like to bring in evidence, I'll do that.
Alrighty, so we're gonna close the public hearing at 12:02. We're gonna bring it back to the board for discussion, and I'd like to start off. The first, you know, I appreciate and want to, thank staff for all the work and everything. There's a lot of information here. I think we definitely need to address that whole expiration date story immediately, after we adjourn this meeting. Because I can see how it could be confusing. But with that, the owner has acknowledged he has the money to do the demo. And I mean, I would be in favor of, of the county doing the demo if this comes back, or the very first meeting of October, if the building's still standing, then you got my support for us to do the abatement. And that basically gives her about a month to do the inspection and get it down. She said it would take 2 days to get it down, and then, it takes her 3 weeks to get the inspection done. It shouldn't be snowing, by that time of October, and it gives her every opportunity. There's no denying there has been a little bit of confusion, it was brought up in a conversation with the code enforcement about the health and safety issue, but it doesn't appear that it was communicated in writing, but although it does state that. Anyhow, I'm of the opinion that it's a bit, maybe it's a bit heavy-handed to vote to send our guys out there, Friday instead of tearing it down. And maybe it would be. you know, show some cooperation on our part to give, until our first meeting in October, which is basically a month. That's kind of how I feel. I mean, I agree it needs to come down.
All right, well, this, to add to that, you know, that I can see that when you get a demolition permit and it says it's for a year, you get a little confusion. But there was 6 certified return receipt letters, citation, correspondence, that made it very clear that wasn't the issue.
Let me point out,
I mean, it's very clear afterwards, the correspondence made that this is a health and safety issue, it needs to come down.
the proposed resolution accommodates the chair's suggestion. In specifically, number 4 says that the property owner is hereby ordered to immediately abate the nuisance by demolition and removal of the damaged building. And if she does not, in a timely basis, as is set forth in number 5, then the county is empowered to come in behind and take care of it.
Number 5 is good.
And I think that accommodates all.
Well, you can adopt the resolution and stay its execution to a certain date to give the property owner a chance to act on it. And if that action isn't taking place, you proceed with the work being done. If I could address, Mr. Chairman, a couple things. I'm going to be in support of getting this cleaned up sooner rather than later. And I want to, one of the things that was in all the pictures, we had a lot of debate and discussion on is, it was somebody else's personal property was being stored, and I think according to the pictures that were highlighted, that the copy of the document submitted by Mrs. Hanson even identified who the person was. And I would have to say that that may be that person's property, but it's on your property. And the responsibility for that is not that person, it's yours. And you've given them due and timely notice to come and clean it up, and all I can say is that they obviously have abandoned their property by not taking advantage. So anything you do to haul that property away, and they want to have a problem with it later on, they had plenty of notice, they've had plenty of time, and so I don't think that is an excuse not to deal with the issue, and I think that needs to be dealt with immediately. You know, the conversation between you and the building official and the code enforcement officer has been clearly defined, and I'm satisfied that that is not a reasoning not to proceed with the abatement based on the fact that we need to know, you know, in terms of the fire safety and stuff. In other words, if you have somebody who can come in, if you've got pictures that you show, that clearly show where you think is where the origin is, whether the building is still standing there or not, you still have the pictures. So if you have, you know, it's usually an insurance company wanting to pay out money that is concerned about that. So, you know, whether you prove it or not, it doesn't make any difference because the fire still happened and there's no money involved. It's really your peace of mind, and you can kind of deal with it. But that's not an excuse for the delay. I think the fact that we don't have the document, there is no March 28th letter or the CAL FIRE report, you know, I mean, that's another side issue. But I do think the testimony from the community, and I know I attended the July 4th, the Paul Bunyan Day Festival, drove in there, and I was over in Westwood on more than one occasion this spring with the elections, and every time I've driven through Westwood in the last 3 months, and my wife was with me one day, and we drove in there, and we were both kind of startled, like just how that, you know, building is still standing there after all this time. And I think if I was a member of the community, that was a situation here locally. We just had a fire half a block away here, burned down the garage, and it kind of threatened the whole neighborhood. But they've already got the garage half rebuilt. I mean, you go in, I know the city of Susanville, we've had a number of fires, and they take, within 30 days, I know we got criticism from the one party who got a letter while the clothes were still smoldering. You know, I'm surprised that you didn't get that letter, that same letter, and that's something that apparently is the practice to try to deal with these kind of situations so they don't take 6 or 9 months. But as far as I'm concerned, I think that the resolution before us is in order. I'm in support of. I would say that if we want to put a delay of its implementation, like maybe a couple weeks, to give you the opportunity to precede the county crews to come in and abate the property. I guarantee you, all that personal property of that other lady's going to be hauled to the dump. All your stuff's going to be hauled to the dump. The cost of doing that's going to be attached to the property, and it'll be a lien. And you can forestall that by taking care of business and not delay any further. But that would be my position, Mr. Chairman.
Mr. Chairman, I would make a motion if you would.
Well, just if I'm just under discussion, I just wanna, then I'll leave it. Okay. I just wanna see, you had mentioned that the resolution does, so what date do we have to jump in if they do not?
Mr. Chairman, item 5 on the resolution indicates that if Linda Hanson does not abate the Newtons by timely compliance, then the Director of Planning and Services will go in and do that. I would suggest that to accommodate the landowner's desire to do it themselves and the board's desire to put a finite date on there, to just replace timely compliance with October 1, 2014.
Mr. Chairman, I would make that motion that we make the abatement and put that October 1st on there and waive the 2,600 in fees citation.
That the abatement is ordered today,
The abatement
but
is
by
ordered
October
today.
1 by the property owner,
If it's
otherwise
not-
the county.
If it's not taken care of by October 1, then we're good to go to proceed with.
And 2,600 in fees would be waived.
If they did it by October
If they
1st,
did it
but
by
if they
October.
don't do it by October 1st, the fees
Okay.
stay.
We have two people doing one motion, so.
No, I'm not doing them, he made the motion, there isn't even a second.
Okay, just a second, sir. Have you got your motion, Madam Clerk?
No.
Okay.
I need that.
What's the motion, Mr.
The
Moon?
motion be to do the abatement by the resolution, they have till October 1st to get it done. If it's not done by then, the county will do the abatement. There was $2,600 in fees against them, citations. That would be waived if it was completed by October 1st.
But not waived if it's not
Waived.
completed.
If it's not done after that, no.
We got it?
Yep.
Sorry.
Thank you.
I'd like to ask the property owner.
Seconded, the motion is seconded, because I'll second it, if the motion hasn't been seconded.
Has not been seconded yet, but it is
I-
minor.
I second it.
Okay, under discussion?
Yeah, I'd like to ask the property owner, can you get this done by October 1st? So I'm holding your feet to the fire. We're trying to work with you guys. You gotta work with us.
Yes, I want to,
Let's-
that's 20 days, I want to say, like the 5th or the 10th, but if you say the 1st, then that's what it is.
Well, earlier today, you said it would be 2 days, so
I
you've
take
got
building.
18 days to
No, no,
figure
no.
out what 2 days you're gonna use.
That's good point.
Okay, so you can get this done by October 1st, Linda?
Yes.
Okay. Then I second Paul's resolution. Motion. You know, Jim did? Okay.
All right.
And I'd like, you know, my heart goes out to you people, you know, I mean, the fires are bad, I was in one once, and it's a bad deal, you know, the decision we make here today, I'm not happy about any of it. I mean, it's our job, someone's gotta do it, and these are the days you don't like, and I'm sorry it happened, and it's got down to this, that there is community public safety involved in it. I'm sorry.
No, thank you very much.
So the motion pending.
Okay, so that's been moved and seconded, all those,
How we gonna go?
we need a roll call.
Please.
Madam Clerk, please call the vote.
Supervisor Chapman.
Aye.
Supervisor Alba.
Aye.
Supervisor Pyle.
All right.
Supervisor Hammond.
Aye.
Supervisor Watson.
Aye. Thank you.
Take our 10
Yeah, we're gonna take our 10,
I took mine a couple minutes ago.
My apologies to the board and to the public, but it is a procedure which requires parents to process. And it's timely, or it takes a lot of time, but it's necessary.
Yeah, I think what we're gonna do, we're gonna come back a 5-minute recess, take up a couple of quick items on the consent agenda.
We need the fire report back?
Oh, yeah.
I'm gonna make a copy.
She's gonna go make a copy right away. She'll take the copy and give you what you lent us to make copies. Thank you. Yes, thank you, Susan.
Yeah.